Ever wondered how some people maintain their wealth across generations? What if I told you they use a tool that's been around since the 11th century? And what if I told you that you can use it too? Hello folks, and welcome back to another episode of Everything Estate Planning. I'm Jim, and in today's video, we will explore an important and fairly complex aspect of estate planning: trusts. Let's take a look at what we'll be covering in today's episode. We will examine what a trust is and how it works, the difference between testamentary and lifetime trusts, how trusts can be structured to serve specific purposes, the potential limitations of trusts and how to mitigate them, and how to set up a trust. If there is specific information you're looking for, we've added timestamps so you can quickly skip to any section you wish to watch. So without further ado, let's get started. First, let's understand what a trust is. A trust is a legal arrangement in which a person, called the settlor, transfers assets such as property, money, or investments to a trustee. The trustee is then responsible for managing these assets for the benefit of a third person, known as the beneficiary. Now, when assets are put into a trust, they are technically owned by the trust itself, not the settlor. This separation of ownership can offer useful benefits such as protecting the assets from creditors, providing tax advantages, and ensuring that the assets are used according to the settlor's wishes. Trust arrangements have their origins in medieval England, where they emerged as a solution to manage and protect property during the Crusades. Landowners who were going off to war needed a reliable way to ensure their estate were managed in their absence. They would transfer their property to a trustee, who would manage the land for the benefit of the landowners or a family or for other beneficiaries. Now, this arrangement laid the groundwork for modern trust law, providing a flexible and secure way to manage and transfer assets across many generations. Today, trusts continue to evolve, serving a wide range of purposes in estate planning and asset management. Before we explore the various ways that trusts can be structured, it's important to understand the difference between the two main types of trusts: testamentary trusts and lifetime trusts. Let me explain what each one is and give you an example of when you might use them. First up, we have testamentary trusts. Now, testamentary trusts are established by your last will and testament and come into effect only after your passing. They are often used to provide for minor children or to manage assets for beneficiaries who may not be capable of managing them on their own. For example, imagine you have young children and you're concerned about what would happen to them if you were no longer around. You could set up a testamentary trust in your last will and testament that specifies how your assets should be used for their care and education. This way you can ensure that your children are financially supported until they're old enough to manage the money themselves. Next, we have lifetime trusts. Now, lifetime trusts, also known as living trusts, are created and take effect during your lifetime. They can be useful for managing your assets while you're alive, providing for you if you become incapacitated. They simplify the transfer of assets upon your death. For example, let's say you have a substantial amount of assets and you want to avoid the probate process to make things easier for your family after you're gone. You could set up a lifetime trust, transfer your assets into it, and continue to manage them as the trustee while you're alive. When you actually pass away, the successor trustee, which you would have named, would take over and your assets could be distributed to your beneficiaries without going through probate, saving time and reducing legal costs. Knowing the difference between these two types of trust is essential for making sensible decisions about your estate planning. Each type has a distinct purpose and can help you achieve different goals based on your individual needs and circumstances. Now that we've covered the two main types of trust, let's explore how trust agreements can be structured to serve different purposes. Each structure serves a function tailored to meet specific needs. We'll provide a clear definition of each structure that is commonly used in estate planning, followed by an example to put things in context. It's important to remember that each of these trusts can be established as either a testamentary trust or a lifetime trust, depending on its intended purpose. First up are property trusts. Now, a property trust allows joint property owners to change their ownership from joint tenants to tenants in common. Now, in joint tenancy, both owners share the property equally, and when one dies, their share automatically goes to the other owner, regardless of any last will and testaments. Now, this can be a problem because it doesn't let owners leave their share to someone else, like their kids or other family members. This can result in sideways disinheritance, where the property might end up with someone outside of the family, such as a new spouse if the surviving owner remarries. By changing to tenants in common, each owner can choose who inherits their share. This ensures the property stays within the intended family and protects the deceased share from being taken if the surviving owner needs care. An important concept to understand here is sideways disinheritance. This occurs when someone who was originally meant to inherit ends up receiving nothing after someone dies. It's common in situations involving stepchildren or after a parent remarries. For example, if a parent passes away, their children from a previous marriage could be left out if the surviving spouse remarries or changes their will, leaving everything to the new spouse or family instead. For example, Mark and Lisa are married and own their house as joint tenants. Mark has 2 children from a previous relationship, Jake and Mia. Now, when Mark dies, because they are joint tenants, the house automatically passes to Lisa, instead of according to Mark's last will and testament. Now, a few years later, Lisa remarries and decides to write a new will, leaving the house to her new shiny husband. And as a result, Jack and Mia don't inherit any of the property their biological father intended them to have, because Lisa now owns it and chooses to leave it to her new spouse. Let's look at an example where a property trust was used. Jane and Tom originally owned their home as joint tenants, meaning the whole property would automatically go to the surviving spouse if one of them passed. However, they decided to sever the joint tenancy and become tenants in common. Now, this means each of them now own 50% of the property, which they can leave to their chosen heir. Now, in their wills, they set up a property trust, specifying that when one spouse dies, their half share is held in trust for their children. The surviving spouse can continue to live in the home, but when they die, the deceased spouse's share goes directly to the kids. This arrangement ensures that each spouse's share of the property is protected, preventing sideways disinheritance and ensuring their children inherit as intended. Now, next up, we've got right to occupy trusts. Now, a right to occupy trust allows someone to live in the property for a certain period, usually for the rest of their lives, without owning it. This trust is often used in estate planning to ensure a surviving partner or family member can stay in the home even after the property owner dies. Now, this trust specifies who gets to live in the property and for how long. Once this period ends or the person dies, the property is then passed on to the final beneficiaries, such as the kids. Now, as outlined in this trust arrangement, this ensures the property remains within the family while still providing a place to live for that designated person. For example, Steve is the sole owner of his property where he lives with his girlfriend, Mary. Steve wants to ensure Mary has a home if he dies before her, but he also wants to preserve the property's value for his kids from his previous relationship. Now, in his last will and testament, Steve creates a right to occupy trust that allows Mary to live in his home for her lifetime. Now, after Mary's death, or if she decides to move out, the property will be sold and the proceeds will be distributed to Steve's kids. This arrangement ensures Mary has a secure home while ultimately protecting the inheritance for Steve's children. Then there are discretionary trusts. Now, these are a biggie. A discretionary trust arrangement allows trustees to decide how and when to give out money or assets to the beneficiaries. The settlor lists possible beneficiaries, but the trustees choose who gets what, when, and how much. Now, this flexibility makes discretionary trust useful for managing family money, protecting assets, and ensuring the right support for beneficiaries is given. They also protect the trust assets from being taken by creditors or in a divorce proceeding, and can also provide potential tax benefits. Let's have a look at an example. Nathan wants to ensure his family is taken care of after his death, but is unsure how their needs will change over time. He sets up a discretionary trust and names his wife, and children and grandchildren as beneficiaries. Nathan appoints his close friend and professional advisor as trustee. The trustees have the discretion to decide how and when to distribute funds to the beneficiaries, depending on their individual needs. For example, they can provide funds for his grandchildren's education, support his wife if she faces financial difficulties, or help his children with business ventures. This arrangement ensures that Nathan's assets are used effectively and benefit his family in the most appropriate ways. Disabled Vulnerable Person Trust. Now, these trusts are set up to provide financial support for individuals who are disabled or otherwise vulnerable while protecting their eligibility for government benefits. Now, the trust ensures that the beneficiary's needs are met, such as paying for care, living expenses, and medical treatment, without the assets being considered for benefit calculations. Trustees manage the assets and make decisions in the best interest of the disabled or vulnerable person, providing peace of mind for their caregivers. For example, Josie has a son, Jack, who is disabled and unable to manage his own finances. To ensure Jack is taken care of after her death, Josie sets up a disabled person's trust in her last will and testament. She appoints a brother and a trusted friend as trustees. The trust stipulates that Jack will receive monthly payments for his living expenses and any additional funds needed for medical care or other necessities. The trustees manage the assets, making sure Jack's financial needs are met without affecting his entitlement to disability benefit. Now, this arrangement provides Josie with peace of mind, knowing that Jack will be financially secure and cared for in her absence. Flexible Lifetime Interest Trust, or FLITs. A flexible lifetime interest trust designates one person as the life tenant, giving them the right to receive income from or use assets such as property during their lifetime. Other nominated beneficiaries, often the children, do not have access to these assets whilst the life tenant is actually alive. Once the life tenant dies, the trust assets are passed on to those remaining beneficiaries. Trustees have the power to manage the assets flexibly, adapting to changing circumstances. This type of trust helps protect assets, prevents sideways disinheritance, and ensures both the life tenant and the remaining beneficiaries benefit as intended. For example, Trevor sets up a flexible lifetime interest trust in his will to provide for his wife, Lucy. Lucy receives the income generated from the trust assets, while the trustees, including Trevor's brother and a financial advisor, manage the trust to meet her needs. After Lucy's death, the remaining trust assets are passed on to Trevor's kids. Now, this arrangement ensures Lucy is cared for while preserving the family's wealth for future generations. Bare trust. Now, a bare trust is a straightforward type of trust where the beneficiaries have an absolute right to the trust assets and the income generated by them. Now, the trustee holds the assets in their name, but must transfer them to the beneficiary when they turn 18 or later if required. Now, this type of trust is often used for holding assets on behalf of minors, providing a simple way to manage and transfer assets and offers tax efficiency by taking advantage of the beneficiary's personal allowances and lower tax rates. For example, Steph wants to set aside money for her nephew Andrew to help with his education. She sets up a bare trust, naming herself as the trustee and Andrew as the beneficiary. Now, the trust holds the money in Steph's name until Andrew turns 18, at which point he gains full control over the assets. Now, this arrangement ensures the funds are managed responsibly until Andrew is mature enough to handle them himself, providing a simple and effective way to save for his future education expenses. Secret trusts. A secret trust is a private arrangement between the settlor and the trustee that isn't clearly stated in the will. It keeps certain wishes or beneficiaries confidential and comes in two types. Fully secret trusts, where the trust isn't mentioned in the will, and half-secret trust, where the trust is mentioned but its details are not revealed. Now, these trusts are used for confidentiality, allowing private arrangements and flexibility, enabling non-public disclosures in the will and addressing sensitive matters discreetly. For example, Margaret wants to leave a portion of her estate to her friend Emily, but prefers to keep this confidential to avoid family conflicts. She arranges a fully secret trust with her estate planner, James, as the trustee. Now, Margaret's will simply leaves a sum of money to James without any further detail. However, James privately agrees to hold the money in trust for Emily, following Margaret's confidential instructions. Now, this setup ensures that Emily receives the inheritance while keeping Margaret's wishes private, thus avoiding potential family disputes. As a note, secret trusts are not common, but they can be useful in certain circumstances. In this section, we'll explore some common limitations of trusts and how you can minimize these particular issues. First, let's address the issue of deliberate deprivation of assets. Now, this occurs when a trust is created specifically to hide assets from creditors, which can make the trust invalid. So, how can you avoid it? First, seek advice from legal and financial experts who can help navigate the complexities of trust law and ensure compliance with all regulations. This reduces the risk of the trust being perceived as a deliberate attempt to deprive creditors. Ensure that the trust is properly structured. Make sure it's established for legitimate purposes such as estate planning or providing for dependents, rather than solely for asset protection. This can be demonstrated by including provisions for a variety of beneficiaries and purposes beyond just asset protection. Clearly document the rationale behind setting up the trust to show that its primary purpose is not to deprive creditors. This could include providing evidence of estate planning motivations, such as supporting family members or charitable intentions. Next, let's talk about the complexity and cost of setting up and maintaining a trust. Trusts can be complicated and expensive, almost always requiring professional advice. Now, here are some ways to handle it. Again, we recommend you engage an experienced professional who can provide cost-effective solutions and streamline the process of establishing and maintaining the trust. Their expertise can avoid common pitfalls and reduce ongoing administrative costs. You should also conduct a thorough cost-benefit analysis to weigh the expenses of setting up and managing the trust against the potential benefits, such as tax savings and asset protection. Now, let's discuss the impact of tax laws. Changes in tax laws can influence how effective your trust is in reducing tax liabilities. Trusts themselves are also subject to taxes like capital gains tax and income tax. Now, here's what you can do. Frequently review the trust structure to ensure it aligns with current tax laws. This includes staying updated with any changes in tax legislation that might affect the trust. Work closely with legal and financial professionals to optimize the tax efficiency of the trust. They can help take advantage of available exemptions, reliefs, and tax planning opportunities to mitigate the tax burden on the trust. Now, set up the trust well in advance and not solely for the purpose of avoiding debts. This helps avoid being perceived as engaging in deliberate deprivation. Ensuring compliance with legal requirements through professional consultation is absolutely crucial. Next, let's talk about the complexity of trust documents. Creating and modifying trust documents can be an intricate process. It's important to cover all potential scenarios. Now, here's how you can manage it. Develop a detailed trust document that covers various contingencies and provides clear instructions for trustees. This includes outlining specific scenarios and how they should be handled. Regularly update the trust to reflect any changes in family dynamics, financial circumstances, or legal requirements. This helps keep the trust relevant and effective over time. Choose trustees carefully, considering their reliability, competence, and willingness to act in the best interest of the beneficiaries. Providing trustees with adequate training and resources can help ensure they adhere to your instructions. Finally, let's discuss the cost of administration and the choice of trustees. Setting up a trust can be expensive and requires ongoing administration. Choosing the right trustee is crucial. Here's what you can do. Clearly explain the purpose and benefits of the trust to the trustees to reduce misunderstandings and potential conflicts. Open communication can help manage expectations and build trust. Ensure trustees are well informed about their responsibilities and the specific need of the beneficiaries. Providing training and resources can help trustees manage the trust effectively. Include flexible provisions in the trust document to accommodate changing circumstances and the evolving needs of the beneficiaries. This can help make the trust more adaptable and reduce the likelihood of disputes. As we can see then, trusts offer great benefits for estate planning, but can have limitations like potential invalidation, complexity, high costs, tax law impacts, and administrative challenges. Mitigating these issues involves proper structuring, clear documentation, regular reviews, professional advice, and effective communication. By addressing these, trusts can effectively manage and protect assets. Now let's get into some practical steps about how you can navigate setting up a trust arrangement. Let's go through these together. First and foremost, it is highly recommended that you seek professional advice when setting up a trust. Trusts can be complex legal arrangements, and a professional such as a solicitor or estate planning specialist can ensure that your trust is set up correctly and tailored to meet your specific needs and goals. Professional guidance can help you navigate the legal intricacies and avoid potential pitfalls, ensuring your trust serves its intended purpose effectively. Clearly define what you want to achieve with your trust. Are you looking to provide for minor children, manage assets for beneficiaries who are unable to do so, or ensure a smooth transfer of assets after your death? Understanding your objectives will help you and your advisor determine the best type of trust for your situation. Based on your goals, decide between a testamentary trust, which takes effect after your death, or a lifetime trust, which is active while you're alive. Then decide upon the structure of the trust. As we've seen, each structure serves different purposes and can be structured to meet your specific need. Choose reliable and trustworthy individuals or an institution to manage the trust. The trustees will be responsible for administering the trust according to your wishes. So it is important to select someone with the necessary skills and integrity. Ensure that the trust is properly funded with the assets you intend to include. This may involve transferring property, investments, or other assets into the trust. Proper funding is essential for the trust to function as intended. Life circumstances and laws change over time. Regularly review and update your trust to ensure it continues to meet your needs and complies with current legal requirements. Professional advice can be invaluable during these reviews. To conclude then, trusts are a powerful tool for managing and preserving wealth across generations, offering flexibility and control over asset distribution. By understanding the various types of trusts and their purposes, you can tailor them to meet your specific estate planning goals. Whether you want to ensure financial security for loved ones, protect assets, or simplify the transfer of inheritance, setting up a trust with the right professional guidance ensures your wishes are honoured and your beneficiaries are well provided for. With proper planning, trusts can offer lasting benefits and peace of mind for you and your family. We hope this video has given you a clearer understanding of trusts and how they can be a valuable part of your estate plan. If you've got any questions or need personalised advice, please don't hesitate to contact us at Elm Legal Services. We're here to help you protect your legacy and provide for your loved ones. Thanks for joining us today. As always, if you have any questions or want to share your thoughts, please drop them in the comments below. We appreciate your feedback and want to continue providing useful information to a broader audience. If you found this video helpful, please give that like button a friendly handshake, subscribe, and hit the bell icon to stay updated on all of our latest content. Join us in the next episode where we'll explore living wills, often referred to as advanced decisions, their benefits, pitfalls, and potential alternatives. Remember, a little planning today can make a big difference tomorrow. So, until next time then, stay safe, stay informed, and stay tuned.